Today's Sentence to Death episode is on Kenneth Eugene Barrett, whose sentence was just overturned this year in 2021. Kenneth Barrett was born in 1962 and did not have the best childhood. He had to grow up very fast and began hanging around the wrong crowds fairly early. His first run-in with the law happened when he was around 18 years old, and he got into a physical fight with Sequoyah County Sheriff Johnny Philpott. Sheriff Johnny was able to win the struggle by punching Kenneth in the face, which caused his jaw to break. Kenneth was hospitalized for mental illnesses in 1986, 1994, and 1995, and was diagnosed with bipolar disorder, PTSD, and depression by a Dr. Woods. Dr. Woods also documented that Kenneth had generational history of mood disorders, depression, and reactive violence. He was prescribed antipsychotic medications, but he used street drugs along with his prescriptions, which was not good for him. In January of 1999, the District Court of Sequoyah in the state of Oklahoma had a warrant out for Kenneth for failure to appear for jury trial and for charges of the unlawful delivery of controlled substances. Kenneth was heavily involved in the making and distribution of meth in his home, and although many had their eyes on him, he was able to avoid being arrested for months. It wasn't until September of 1999 when the District 27 Drug Task Force received a tip from an informant. The supervising agent by the name of Clint Johnson was told by the informant that Kenneth said he promised to kill any officer who came to arrest him. Kenneth also started dealing at night because he believed that the law would not be able to follow through with a search warrant at night. With that information, Clint Johnson prepared paperwork for a search warrant that was ultimately approved. The search warrant allowed the task force to follow through with their search at any time, which included nighttime, and it also did not require them to knock or announce their presence due to the quote-unquote violent and unstable nature of Kenneth. They also had no idea how many people would be inside the home, but they did know that Kenneth owned firearms, and with him threatening the lives of police officers, they had to be prepared. Clint got in touch with the Oklahoma Highway Patrol tactical team because Kenneth's home was only accessible by going through a dead-end road, and he had relatives that lived in homes nearby. The TAC team was experienced with high-risk search warrants, so they were prepared to help. On September 23, 1999, the TAC team spent hours surveilling Kenneth's home in a white, unmarked Ford Bronco. In Kenneth's home that day was his cousin, who brought the car to his attention, but Kenneth said that he knew it was law enforcement and would go out in a blaze of glory and did not care. After surveilling the home, they came up with a plan and wanted to execute it that same night. The front gate to Kenneth's property was locked, so they decided to bring 2 unmarked vehicles and 1 marked highway patrol vehicle with 2 law enforcement officers in each car. The vehicles were going to go on a private driveway and drive through a ditch onto Kenneth's property, and they would walk on foot the rest of the way to Kenneth's house and go inside through the front door. A 4th vehicle, which would be a marked highway patrol car, was going to station right outside of the locked gate, and the officers in that 4th vehicle were going to climb the fence and provide cover. A 5th vehicle, which was another unmarked Ford Bronco, would park in the driveway of Kenneth's mother's house. It was now 12:30 in the morning on September 24, 1999, and the TAC team was now ready to follow through with their plan. The 5 vehicles headed towards Kenneth's property. Some officers climbed the fence to enter Kenneth's property, while the other unmarked vehicles took the other route, with the first vehicle having their lights off. The officers that scaled the fence made it closest to the house first, and saw Kenneth's son Toby outside and immediately apprehended him. While being put in cuffs, Toby yelled out for his dad. Now aware of the fact that law enforcement was on his property, Kenneth grabbed his firearms and began shooting towards the vehicles. In the first vehicle was Officer Hamilton and Officer David Eels. Their vehicle was rattled with bullets, and Officer Hamilton was struck in the face from bullet fragments. They were unable to turn on their lights for a clear view because of the car being severely damaged, so the second vehicle drove a bit closer with their emergency lights on, which lit up Kenneth's residence. Officer Hamilton, injured and not returning fire, hid by laying down on the vehicle's front seats, and Officer Eels got out of the vehicle on the driver's side. He attempted to make it to the back of his vehicle and in front of the vehicle behind him, but Kenneth was able to shoot him 3 times. Officer Hamilton noticed that his partner had been struck, So in order to divert Kenneth's attention, he threw a device out of the driver's side window that caused a flash bang. The distraction worked and Kenneth stopped firing momentarily. Officer Hamilton then got out of the vehicle in an attempt to find his partner, but once out of the vehicle, he was shot in the left shoulder by Kenneth. Injured and on the ground, he noticed his partner, Officer Eels, unresponsive and face down in the ground. Another officer, Officer Mannion, came to assist, which allowed Hamilton to see where the shots were coming from. He noticed Kenneth in the doorway of his house holding a rifle, so he fired 2 rounds at Kenneth, but every shot missed. Officer Mannion then left from behind the first unmarked vehicle, where he attempted to help Officer Eels, and snuck to the side of Kenneth's house and fired 2 shots through a window that was facing the doorway. Kenneth was struck in the leg and other lower extremities, but was still alive. He fell to the ground and was approached by Officer Hamilton, who instructed Kenneth to get up, in which Kenneth responded that he wasn't able to because he was shot. 3 officers then dragged Kenneth's body from the house to the front yard, put him in handcuffs, and proceeded to search his property. Although no one else was home, the TAC team was able to find materials used for Kenneth's meth production, weapons, and over $2,000 in cash. Kenneth had fired around 20 shots at the TAC team, and the 3 that hit Officer Eels landed in his chest, the left side of his abdomen, and his right arm. The team was unable to provide assistance during the shooting, so the ambulance arrived late, and once at the hospital, Officer Eels was pronounced dead. Because of who Kenneth killed, it was considered a federal crime, and because of the 1994 Federal Death Penalty Act enacted by Congress in 1994 that stated that if a defendant is convicted of a federal capital offense, the government can petition the court to have a separate sentencing phase, and the government chose to do just that. Kenneth was initially charged with first-degree murder and 3 counts of shooting with intent to kill on September 24, 1999, but it changed to 1 count of shooting with intent to kill and 2 counts of discharging his firearm with intent to kill. Although charged in 1999, his trial did not start until late 2002, and there was a hung jury on October 19, 2002. The retrial began a couple of years later in the beginning of 2004, and the jury did not feel as if Kenneth intentionally killed Officer Eels. They rejected the charge of murder, and he was acquitted of the intent to kill charges, and they believed it was first-degree manslaughter and assault with a dangerous weapon. He received his sentence on April 19, 2004, and was sentenced to 20 years in prison for manslaughter and 10 for the assault and battery convictions, and they were to be served consecutively, which would make it a total of 30 years in prison. Kenneth had no intentions of appealing this sentence and was fine with the judgment. Towards the end of 2005, though, his federal case began because the Eastern District of Oklahoma charged him with 8 different counts. He was charged with intent to kill a law enforcement officer in the performance of the state law enforcement officer's official duties and for carrying a firearm during and in relation to drug trafficking offenses, which also resulted in death. In less than a month after trial began, Kenneth was found guilty by a jury on November 4, 2005, and they believed with his threats, he intentionally killed and knew he was going to do so all along. With his death sentence came automatic appeals and many points argued in order to try and get his sentence overturned. One point was that one of the jurors should have been dismissed because during a lunch break, he had a conversation with one of the officers who was also a witness. While talking, the juror realized that he knew one of the officer's family members, but the juror later testified that they did not discuss the case at all, and the court believed the testimony. Another point for the appeal was that there was no evidence to warrant a judge approving a no-knock, any time of day search warrant, and that his crime was not premeditated. This was the response. Mr. Barrett had been aware for some time of the outstanding warrant for his arrest, and anticipated the law enforcement officials would come to his house to arrest him at some point. Despite that awareness, or perhaps because of it, Mr. Barrett exhibited a defiant attitude towards law enforcement officials. On the front gate leading to his residence, Mr. Barrett had installed a sign reading, "Keep out, I don't give a who you are. If you cross my gate or come on my property, I'll shoot." Further, in the months and weeks leading up to the date of the shooting, Mr. Barrett regularly told friends and family that if law enforcement officers came to his house, there was going to be a shootout, he would shoot the first police that came through his door, and he was going to take out as many law enforcement officers as he could before they got him. Indeed, on the evening of the shooting, Mr. Barrett observed 3 of the TAC team members drive by his residence in an unmarked vehicle and subsequently stated to his cousin Travis Crawford that he knew the vehicles belonged to law enforcement officials, that he didn't give a if they came to serve the arrest warrant, and that he was going to go out in a blaze of glory if they did so. Mr. Barrett's conduct in the months, weeks, and days leading up to the shooting incident suggest his threats were far from idle. Mr. Barrett possessed multiple firearms at his residence, including 5 rifles, 3 shotguns, and 2 pistols. During the day, Mr. Barrett typically kept a rifle nearby. He also carried a 9mm pistol in his pants at all times. As for the night of the shooting incident, the evidence presented at trial was more than sufficient to have allowed the jury to reasonably find that Mr. Barrett knew it was law enforcement officials who were approaching his residence en masse. In 2015, however, the 10th U.S. Circuit Court of Appeals ordered that a new hearing be held in the U.S. District Court for the Eastern District of Oklahoma to determine whether or not Kenneth had sufficient legal representation. A magistrate determined that he did not have sufficient legal representation, and in 2019, a federal judge agreed with the magistrate's decision. Given Mr. Barrett's recollections of childhood and adult head injuries, his performance on tests, and the records of at least some head injuries, the jury could reasonably have concluded Mr. Barrett suffered from brain damage. The death sentence was overturned, but the 2 life sentences remained for his weapon charges. His federal death sentence was being carried out at the U.S. Pen in Terre Haute, Indiana, while awaiting his new sentencing hearing. On January 19, 2021, the United States Court of Appeals for the 10th Circuit was able to read over all of the evidence left out of the initial trial, and they reversed the district court's decision of finding no prejudice, and the circuit judge ended by saying, "I lack confidence that the outcome would have been the same had this mitigation evidence been presented to the jury. The experts were well credentialed, there was supporting evidence, and their examination of Mr. Barrett was apparently more extensive than those conducted in the past. The damage to Mr. Barrett's reasoning capacity may have been responsible for his plan to go down in flames. And there is a difference between blustering about having a shootout with police and actually deciding to go through with it. So impairment of his judgment during the raid may have been ultimately responsible for his deadly actions. A reasonable juror might well have decided that the mitigating evidence precluded a death sentence. In that regard, I note that the state jury did not find Mr. Barrett guilty of first-degree murder, and the federal jury imposed the death penalty on only 1 of the 3 death-eligible offenses. Kenneth is still in prison while awaiting for a new sentencing hearing. Do you think once new evidence is presented, he will be spared from the death penalty, or do you think he will receive the same sentence?